morning, and welcome back to Thompson Hine's weekly coffee chat series. My name is Marc Miner, and I'm a senior counsel in Thompson Hine's investment management practice group. Joining me today is David Brown, managing partner at Topside Group. Excited to have him along with me. Today we will address corporate governance issues that municipal issuers, advisors, and other fiduciaries may need to consider in the current regulatory environment. If you have questions or comments, we encourage you to join the discussion by using the Q&A box on your control panel. We will address your comments throughout the presentation and promise to leave time at the end for any questions that come up during our time together. So with that, we'll get started. So our topic today, municipal issues. David, before we get started, why don't you just tell us just a little bit about your background?
Thanks, Marc. My name is David Brown, and I am one of the managing partners at the Topside Group. I'm a lawyer by training and worked in-house at various investment banks, and then for a while at the New York Attorney General's office, where I was the head of the Securities Bureau, and that's where I met Marc. And after that, I ran the Dormitory Authority of the state of New York, which is most years is the second or third largest issuer of municipal bonds in the United States. And since then, I've gone back in-house and done other compliance style work. I founded the Topside Group with my partner back in 2018, and we are a boutique advisory firm that works with financial services companies, both insurers and banks and securities, and we have expertise in cryptocurrencies and cybersecurity, and we do a bunch of different stuff. So I'm very pleased to be part of this morning's presentation.
Thanks a lot, David. If things really go sideways, I will definitely tell stories from back in the old days, so behave yourself. So just a brief background, most of you who are listening in today or maybe checking in later may be familiar with this space, but I thought I'd just give just a brief background. So municipal securities are generally exempt from registration under the 33 Act. And the Tower Amendment to the 34 Act prohibited both the SEC and MSRB from requiring municipal issuers to file disclosures in advance of offering. But they're still subject to anti-fraud provisions, and very often is these provisions that hang up such institutions. We'll talk a little bit about that today. So beyond fraud, the SEC enforces authority through dealers, and under the 34 Act and Rule 15 C2 imposes due diligence requirement for the dealers. So there are other provisions that we will talk a little bit about today. It's important to note that there are several states that figure prominently in the enforcement space as well. So David, who needs to be mindful of the regulatory scheme in this space? Who are the players?
Okay, so municipal finance is a little bit of a backwater in the world of enforcement. There are a lot of issues there, and it's you have to sort of think about maybe three groups of actors. There are the issuers of the securities themselves, which are not-for-profit entities. Often they're states or government entities, and sometimes they're like charities. Like imagine the Sisters of Mercy Hospital wants to build a new wing. They will want to, since they are not-for-profit, they can issue bonds, and the coupons they pay, if they're munis, are not subject to taxation. So effectively, they can get a much better rate of return. They can get a better financing rate for people who are eager to buy their bonds. The Sisters of Mercy in this example is like a borrower. They can't issue the bonds directly, and so they have to go to some state or local entity to issue the bonds. So the one bucket, the first bucket, is the issuers and borrowers, which are sometimes the same entity, and sometimes in the example of the Sister of Mercies, it's called a conduit. sometimes they are two entities, but they are the ones who are actually issuing the bonds. The money goes to them, they make the interest payments. The next set of actors, and one that has may have a lot of compliance type issues to think about, are muni advisors. They are ones who typically help issuers / borrowers, raise money and advise them as to what to do. Often they will play a role in introducing them to the third actor in our scenario, which is the underwriters, the dealers, the broker dealers. They're the ones who actually underwrite an issuance of municipal securities, and it's just like underwriting a stock issuance. They buy it all and sell it as fast as they can, almost instantaneously. So those are the three actors, and they have different types of regulatory risks, different types of enforcement risks, different types of fiduciary duties, which we can go into. And you see, Marc will probably talk about some of the cases. You can see cases for each of them, but in order to think about it, you got to sort of have the three buckets in your mind.
Were there any significant changes? Obviously, most that are on the phone will be familiar with Dodd-Frank and the passage of Dodd-Frank and changes that imposed in the space. For corporate governance purposes and those who are responsible with making sure that the institutions themselves are staying on the right side of the law, obviously, and hopefully out of the crosshairs of enforcement. What are some of the high-level issues that they might want to be mindful of?
Okay, the big one, it sort of depends who you're advising. In terms of new stuff or new-ish stuff, and things move kind of slowly in the world. I mean, as I said in the beginning, it's a little bit of a sleepy backwater of the securities world, right? But the new-ish thing is under Dodd-Frank, there is now a fiduciary duty for muni advisors. That, was sort of a long time coming because they always walked and talked like fiduciaries, but it's now official, and we're beginning to see some enforcement cases on that. And look, muni advisors can make a lot of money, and they are in a position where they are subject to various types of financial, blandishments. That is, if you're a muni advisor, you're going to play a big role in selecting who the underwriting firm is, who's the broker dealer who's going to get the business and get to underwrite it and make a bunch of money. You have to be very, very careful not to be receiving things of value that warp your judgment one way or the other. There are, so anyhow, if you're advising someone who's a muni advisor, the touchstone is probably the fiduciary duty and the avoidance of conflicts of interest.
Well, certainly fiduciary duty is a thread that I think that runs through a lot of these issues, and where institutions fail to do that, sometimes more blatant than others, you can kind of lead into some of the enforcement realm. Now, we generally find, as I always say, the overwhelming majority of institutions and the players that you describe are trying to scrupulously follow the rules. But I think investment in this space still has a long way to go. David, you may remember, I guess over a decade ago, some of the pay-to-play cases. As a state securities administrator, I know I was involved with a lot of those investigations and actions. The New York AG's office, in fact, figured prominently with the Hank Morris case. You mentioned that in this space we have municipal interests, and municipal interests also have rules that they are required to follow. There's a tremendous amount of money involved in this space, as you mentioned, and sometimes gatekeepers, at least the ones who begin to recognize the levers of power that they held, were taking bribes really to make certain introductions in the space. This is the case for Hank Morris, who used pension funds for a kickback scheme, where he personally received nearly $20 million in fees by steering the money manager work to the fund. Under the Martin Act, that was a felony, and he received a sentence of a 1 to 4 year stay in one of New York's finest institutions. In the wake of those cases, there were several other states that also brought actions for similar activity in their states. Some of those players who are gatekeepers use their political leverage in other places, and you started to see other states replicate those cases. So to me, the fun note is that now, a decade after that, and now that the SEC has passed additional rules in this space, and FINRA passed very specific pay-to-play rules, we see that some people have still not really learned their lesson. The SEC is involved in this space.
And there is in muni finance in particular, there are pay-to-play rules that are, if you're representing a dealer, this is really important. If one of the employees of the broker dealer makes a political contribution, it can bar the entire firm for 2 years from doing any business with the relevant state agencies. So you have to be, one of the aspects of a compliance program in a broker dealer is to keep track of where political contributions are going and make sure that you're not giving any that might have the effect of knocking you out of the box for a couple of years.
Well, that's a pretty severe consequence. I know when these rules first changed, there were some who made contributions and wanted to avoid that. I've had to advise clients to make sure that the political contributions policies that they have and the practices for monitoring that are well established. Sometimes you can incidentally do that. We certainly saw this with recent administrations with a vice president who had formerly been a governor, and that there are many institutions in that state had made lots of contributions to that individual, and they had to decide going forward, whether they wanted to continue that support or return the money and go after business. And so it can be a thicket. People are getting to, learn more about and understand better and make business decisions about the consequences of that. But being on the sideline for 2 years is usually not an option that lots of institutions want to undertake. The SEC within the past year or so had a case involving just this, a pay-to-play investigation. I think it's Kang, Shuren, and Kelly. We'll go back to the details if time permits. But this was a group who were participating in a bribery scheme for access to a municipal investment. And so the SEC, if you go to its page for this, has that prominently displayed, and that's obviously for a reason. Now, the New York Post announced in its journalistic style about a week ago that Hank Morris is now a free man, and he's become a producer, and he's producing a play about his life story. And so this will be fascinating. Apparently, it will prominently figure Andrew Cuomo, which some of you may know before he was ever governor, was the attorney general in New York, and the attorney general in charge at the time that his cases began. Although they bled over into the Schneiderman administration when he was ultimately sentenced. So I don't know what kind of cape, a black cape, or black hat he's going to wear in that story. But coming to a Broadway show near you. So we'll wait for that. I hope I'm not even a bit character. So beyond pay-to-play cases, a lot of the cases I think that we tend to see in this space are sales practice and sales related cases. And sometimes they involve the institution, the issuer who has provided certain information or omitted information or provided information that is deemed to be materially misleading, sometimes on the performance, sometimes on the nature of the investment itself, all the typical things that under the definition, something is material if a reasonable investor might find that fact important. It doesn't have to be determinative, important in the total mix of information that they have to invest or not invest. And so we see lots of cases involving this. The worst really involve efforts to clearly spin mistruths or lies or try to avoid the rule altogether. One that has been in the news rather recently is this practice of flipping, which is using unregistered persons to get priority and fill in the sale of the municipal offerings. So in the grand scheme, the non-dealer has a lower priority. And so there are brokers who were using unregistered people to make their fills because they know that the unregistered people would have the priority. And then they would flip those out. And this was an entire scheme. It ultimately involved, I think, 11 different institutions and individuals. And
Right.
this effort to avoid the rule caught everybody in a big net.
Yeah, it's interesting because now we're talking about what happens when the underwriter is selling the bonds to the market. And the way things are set up, the underwriter is first supposed to sell them to actual people, individuals who seriously want to own them. And then if there are any left over, sell them to broker dealers, because you don't want to sell it to people who are like, the idea is you're not going to sell it to sort of hot money that just wants to flip them and turn them over right away. You're hoping to find homes for your bonds with people who are interested in holding them. Because there is some value, and Mark and I, this is my pet peeve about this market, but because the bonds are slightly underpriced, apparently, there's a lot of demand that people really want to get them. And the case that Mark is talking about is one where a broker dealer wants the bonds because they can flip them for a profit and engages in a subterfuge to get them by getting people on its behalf to go out and pretend that they want them for themselves, but in fact, they're really just kind of proxies for the evil broker dealer.
Right. It was interesting when you look through the facts of this case. As often happens, the regulator, the SEC in this case, went directly to the email communications on the days that these products are being offered and sold. And time again, you have both the unregistered reaching out to the broker dealer or the broker dealer reaching out, really describing exactly what they wanted, how much they wanted to fill or what was offered. And so it was pretty easy to, I think, unravel this a particular case.
Right. Well, Mark and I have done a lot of email-based cases, and the good thing from the enforcement regulator's point of view of these cases is the email document request can really be a rifle shot, because if you know the time of the trades, you can ask for the communications in a time window, because these communications have to be happening within a window that's relatively short, and also kind of have to mention the security. So it is not as onerous as it might be to tease these things out. They'll either be to get them in discovery. You can either get them they may be in email or in chat, but it's relatively small universe of documents.
Right. So, for the practitioners out there, whether you work for a company or serve clients who do, this is a good time to be mindful that the SEC within the past month or two has brought a spate of cases against institutions for their failure to monitor, either have policies and procedures reasonably designed to prevent or detect, or to do so negligently, where anyone in your institution is using a platform, sanctioned or unsanctioned. In some of the most recent cases, it used to be that you found activity in email, and people would go to Bloomberg terminals, to look for for other communications. Now everybody has a device in their pocket, and while you can have prohibitions against using that, very often people are, if you have someone's number, they're simply using any number of platforms. Some of them are problematic in that they are locked down. Some of them, the information is not detained, and clearly that would be a violation at a minimum of your books and records rules, and where nefarious activity is taking place. That might be the exact place they want to go. So you want to make sure that you have policies and procedures that seek to prevent that. It may not be enough anymore to simply have in your policies and procedures, thou shalt not. You may want to either periodically look or check or survey to make sure that that is being, those rules are being followed. So let's move on a little bit to issuer cases. I know this would have been particularly important in your role. So these are cases where there are material misstatements by the issuers themselves. We've seen lots of these over the past several years. For some reason, many of these cases involve schools
Yeah.
or colleges that are seeking to raise money. So I don't know, who got schools in their bonnet, but when you look through the material misstatement cases, case after case appear to involve an issuer who either has materially misstated the profitability or something important in the offering, and we see cases against professionals who have assisted them.
Yeah, there's a terrible case, one of the ones that you sent me, where the auditors are under pressure and they're being told that they have to issue their opinion by the end of the day. They just have to, and they go ahead and do it. And of course, it turns out that they hadn't, completed all of their audit procedures, and everything heads south. So that they were on the receiving end of an enforcement action by the SEC. And there are a number of these, as you say, are schools, and these are, going back to the sort of the three buckets, these are ones where it's a borrower, unsophisticated, smallish borrower, that is going to have to go and find someone to sort of issue bonds for it, and they are frankly just cooking their books. And while they're the ones who quite rightfully are getting in trouble for this, it is kind of a failure. It shows the system is not working, because there is the issuer, which has some, I think, responsibility to look at these things, as well as muni advisors, and it's a shame that those happen. There also are really big ones, though. There was a really giant one a few years ago for the Port Authority of New York. Huge case, $1.8 billion bond issuance, where the SEC said the Port Authority had failed to disclose that some of the road projects it was raising money for were subject to litigation risk. So that's different. Also serious, but kind of it just shows it can happen anywhere, I guess.
Well, that's a perfect lead-in, I think, to the next topic that I wanted to cover in the few minutes we have left. So anyone who is responsible for making sure that these institutions, whether you're chief compliance officer or an officer of the company, yourself or general counsel, should be aware that the SEC right now is looking very closely at issuing issuers providing full and fair disclosure. And so ESG has been the topic of the day in lots of conferences lately, and so we think that in the drafting of the description of the products and services, many institutions are, whether you are responsible for a portfolio, you ought to be thinking about whether or not there are appropriately disclosures for ESG, which is environmental, social, and governance.
Government, yeah.
Right.
Yeah, I think that the idea is if you have an ESG bond, there should be more demand for it. You get a better price and therefore kind of pay a lower interest rate. So there's a reason people want to do this, and it's an emerging area, as Marc says. And I think the bottom line is you are getting a raft of disclosure issues if that's the route you're going down. No reason not to do it, but there's additional stuff because you have to say, this is what I'm going to do. Often you need to get a third party in to say, yeah, they're really doing what they said they were going to do. And then sometimes you have an obligation to report back and say, yes, it's going fine. We actually are putting in the solar panels or whatever it is. So there can be all kinds of sort of bells and whistles that could lead to exposure that you wouldn't find in a regular issuance.
When you were in your role at the Dormitory Authority, did you find that it was really particular attention paid to this space? Sometimes I have read some of these materials, and I've left with more questions than I had before I read it.
I was there I left in 2007, and I still take credit for the first issuance of green bonds in the United States, but luckily there were none of these emerging standards there because it wouldn't meet today's standards. However, we were raising money for dormitories to be in the SUNY system, to be retrofitted, to be more energy efficient, with some of the savings earmarked to going and paying off the interest on the bond. So that is a kind of a green bond. They are really, really a thing now, and I can't pretend to be an expert on all the different things that are happening, but it is something that we were thinking about even back then, and it's a very big deal now.
Sure.
And it's a beautiful thing. I mean, you could have the capital markets help green the planet if you really get this going, and you pay for the bonds with the savings from helping the environment. Then all of a sudden, this isn't a do-goody Mickey Mouse thing. It's a real way the capital markets can help. So it's a very worthwhile thing.
Oh, well, it certainly captured, the attention of lots of parts of the financial markets, and doing well and doing good, don't have to be mutually exclusive. But while you're doing that, know that the SEC has appointed a czar over this space and a whole task force to make sure that as people are being lured into or willingly looking for investments that are a part of any of these three buckets of ES&G, that they're doing so appropriately. Also know that the plaintiff's bar is looking very carefully at anything that the institutions are saying about their commitments in this area, and there have already been dozens and dozens of actions filed for institutions who are claiming to be at the forefront of some environmental change or some social change. And so people should be mindful about that. Well, look, this half an hour has come and gone really quickly. David, thank you so much for jumping in with me today.
Hey, thank you for having me.
Well, we're at our time. I definitely want to be respectful of everybody's time. So I want to thank you for attending the coffee chat here today. There are routinely coffee chats that we participate in. We encourage you to attend the series, and not only this chat, but all the coffee chats that we have are available on Thompson Hine's website. David, thanks again, and thanks for everybody for joining in.
Thank you.